All right. So in the nature of time, why don't we go ahead and Justin, I'm glad to see that you have presentation ability. So
Yeah.
I'll let you go ahead and get started. For those of you who don't know about us, we're Cal State Fullerton Startup Incubator. We help startups. We help a lot of people in that initial phase. I call it going from 0 to 1 and really in the idea phase. But we've also been called upon to work with people who have been in business for a couple of years, maybe 1 or 2 years, and they've hit that plateau and they really need that new energy, the new ideas to come in and revitalize their business. So even though we are a startup incubator, we are there for people who are in the idea phase, but also people who want to kickstart their business again. And anyway, I'll go ahead and put some links in the chat as we're going through. With that, we put on events. I'm happy to and pleased to present to you Justin Sanders. Been doing a great job here. Excellent patent attorney. Let me go ahead and hand it over to Justin. Further introduce yourself and tell us what we need to know about patents.
Yeah, well, first off, thanks for having me, and everyone, thanks for attending. Again, yeah, my name's Justin Sanders. I'm a patent attorney with a local firm called Entralta. Just real quick, I won't spend too much time about our firm, but we are what you would call a transactional law firm. So we deal primarily on the side of helping clients identify what they have, protect what they have, and monetize what they have. So the one thing that we don't really handle is litigation. Realistically, most cases don't get to that stage in the process. We do help clients enforce their rights as far as sending cease and desist letters, negotiating settlements, things like that. But if push comes to shove and a lawsuit has to be filed, that's where we hand it off to an actual litigation firm. But anything leading up to that is in our wheelhouse. We are actually, and for the past about 6 or 7 years, we have been a virtual law firm, meaning that we don't have a physical office space. Instead, we just work out of home offices. So we do still meet clients in person when they want to meet in person, but by and large, we're just meeting with clients. Well, now for the past about roughly 6 months, we've been meeting with clients exclusively by Zoom and phone and everything. But even before that, that's what most clients preferred anyways. But it just helps us keep our costs down, our overhead down, which keeps our fees low for our clients. So we cater primarily to startup companies and solo inventors. So we're very mindful of the shoestring budgets, and we keep our costs, we keep our fees kind of priced for that type of client. And everything we do is based on flat fees rather than hourly billing. So yeah, clients tend to like that. So what we'll definitely cover today are those first 3 bullet points. So I'll give you just a little bit of foundation as far as just some patent basics, things to keep in mind as far as how the patent process works and things like that. And then we'll touch briefly on some patent searching options that are available to you. And then also some provisional patent drafting and filing advice should you want to try your hand at preparing and filing a provisional application on your own. Now, if time permits, we'll also touch on some trademark topics as well, but I'm guessing that we probably won't have time for that, but I'm always happy to put on another presentation that focuses on the trademark aspects, and always happy to answer questions as well on that issue. I should also note too, if anyone has any questions at any point, just feel free to unmute yourself and stop me at any points. We're going to be covering several things, and I've found that it's easier just to tackle questions as they come up rather than saving questions until the end. I know there is a chat window. I'll try to keep my eye on the chat window as well if a question pops up, but best way to make sure that I'll be able to answer the question is just to interrupt me and ask it as they come up. So jumping right into it then, patents, just a little bit of background. A patent is basically, it gives you the right to exclude or prevent others from making, using, selling, offering for sale, or importing infringing goods or services. So it's this right of exclusivity that is given to you as the inventor or the owner of technology by a particular government, whether it's the United States or a different country. And in exchange for teaching how to make and use that invention, assuming it's sufficiently unique, which we'll get into, that government will give you this limited monopoly, this limited period of exclusivity, within which time only you are authorized or allowed to either practice the invention yourself or choose who else gets to practice it. But if someone does it without your permission, that's when they would run afoul of your rights, and you would be able to take action against them through what's called a patent infringement lawsuit. So because of that exclusivity, as you can probably appreciate, that gives quite a bit of value to a company, both because it keeps your competitors at bay, it allows you to do something that your competitors can't do without your permission, and it also attracts potential investors, licensees, purchasers, etc. Again, because of that exclusivity, that edge on your competitors that you have by virtue of that patent. But one important thing to keep in mind is a patent is not a grant of permission to take your product or your service to market. So for one, you don't have to have a patent to take something to market. It's just if you want to have that exclusivity, that competitive edge, that's where you'd want to get a patent if it's a viable path for you or for your product or technology. But it's not a requirement to take something to market. But at the same time, if you do obtain a patent, that doesn't mean that you have what we call freedom to operate or the ability to take that to market, because it could be the case where if your system is made up of a bunch of smaller components, one or more of those components may have already been patented by somebody else. And if that patent is still active, and you take that component to market as part of your larger product without that patent owner's permission, you could be infringing that person's patent. So just because you get a patent doesn't mean you have freedom to operate, and that's always another consideration to keep in mind before going to market. And that's research that can be performed to kind of better determine that issue, but just keep that in mind as you develop any new technology or new product or service. It's also important to note, as I kind of alluded to, rights are country specific. So if you want to have patent rights in the US, you have to file a patent application in the US and obtain a patent. If you want rights in Japan or China or elsewhere, you've got to go through that process in each individual country. There are some exceptions to that, like for Europe, for example, you can file what's called a regional application, and it kind of protects you eventually throughout the entire EU rather than having to file separate applications in each individual European country. But that's one of few exceptions to the general rule that it is kind of on a country by country basis. But as I'll get into in a little bit, as long as you file your US application as a starting point, preferably before you have any public disclosure of your invention, you can kind of string these applications along, meaning that you don't have to file them all at once. You've got some time windows to play with, within which time you can file these further applications in whatever countries are ultimately of interest to you. So as far as what is patentable, so there's always this threshold issue of whether something is even comprises patentable subject matter or not. And as you can see here in this list, I mean, it's almost anything under the sun is potentially patentable. So the primary examples would be processes or methods of doing things, machines or articles of manufacture, even things like compositions of matter, whether it's like a pharmaceutical composition or some other formula that you've come up with. And also any improvements on those things, meaning that you don't have to come up with something that's completely brand new in order to get a patent on something. More often than not, things that are being patented are improvements on things that are already out there. So if you've come up with the next best chair, if those improvements to the chair are sufficiently unique, then you could get a patent on those improvements. Now, obviously, if you get a patent on something that's an improvement, You're not necessarily preventing anyone else from making a chair, but rather you're preventing people from making your improved version of a chair. So it's those improvements that you would be getting a patent on in that case. But those types of patents are obviously valuable as well if you've come up with the next best version of something. Now, things that aren't patentable, they're kind of obvious, but it is worth mentioning. So things like laws of nature or natural phenomena, things that are just naturally occurring. Obviously, if you discover something new, some new law of nature, you've discovered it rather than invented it. And patents are reserved for inventions, not discoveries. The other kind of common category these days is what we call abstract ideas. And if you're familiar with kind of the patent world these days, particularly as it pertains to software, the phrase abstract idea is kind of a hot button issue lately, because some things, if too broadly described, not concretely fleshed out in a particular implementation, could run afoul of this or fall into this category being an abstract idea, and therefore not even passing that initial threshold of being patentable subject matter. And I'll kind of get into that a little more in a minute here. But so as the phrase implies, though, if something is too abstract, too high level, then it's just not going to be something that's protectable, because you can't, or I should say that the general public wouldn't be able to wrap their arms around what exactly it is you've developed or what you've invented if it's not sufficiently fleshed out in like a concrete implementation, where they can say, okay, well, I see this is what you've patented, so I'm going to steer clear of this. But if it's just an abstract concept, it's too vague typically to kind of define the metes and bounds of what it is you've developed. And so because of that, abstract ideas aren't patentable. So as you see, some examples, and the examples that the courts currently follow are things like mathematical concepts. So if you come up with a new mathematical formula or something like that, methods of organizing human activity, mental processes is kind of another obvious thing. If something's occurring just solely in someone's mind without any kind of tangible result or end product, something like that's not going to be patentable subject matter either. There has to be some kind of tangible aspect to it. And that's not something necessarily that you would be expected to figure out on your own. But if and when you get to that point of wanting to go down this path, that's something myself or another patent attorney or patent agent could discuss with you and kind of give our gut feeling as to whether what you've developed would cross that threshold of being patentable subject matter or not. Particularly, again, with software, that's primarily what I deal with myself, though I'll handle the whole gamut except for any kind of biological or pharmaceutical subject matter. But mechanical devices, software, anything computer related or anything really high tech, design patents even, it's all kind of within my wheelhouse. So I'm certainly in a position where I could provide at least my opinion as to whether something would clear that threshold or not. And I'm always happy to have those conversations. So just real briefly, if you are in a business that is kind of software related, and if what you might be trying to patent is software related, again, the abstract idea issue is something that would come up, and particularly because when you're trying to protect software, you're not claiming it as software per se, but rather you're claiming the method that's being carried out, the algorithm that's being carried out by the computer when your software is executed. So it's not such and such software, but rather a method of doing such and such as executed by a processor or something like that, comprising the steps of A, B, and C, whatever the software, whatever steps the software goes through, from receiving the inputs to processing those inputs and then providing the outputs. Each of those steps along the way would be what you would kind of claim in the patent. And so software is typically looked at as what we call a business method, or just a method of doing something. And software is obviously just one example. You could have a method of manufacturing something, a method of using something. There's lots of different types of methods that could be patented, and software is just one type of method. So the thing to keep in mind, though, if you are going to try to prepare your own application, your own provisional application, if it's software related, the more technical you can get in your descriptions, the better your chances are going to be. So if you're trying to approach things at just a real high level, where you're saying things like reading the input, or accessing a database, just real high level functions that kind of computers do generally, it's going to be a relatively weaker position as compared to going into the nitty gritty of the technical details of what's going on behind the scenes, and just being as technical as possible so that we can later argue that what your invention is a technical solution to a technical problem. And it's very gray area right now, unfortunately, for this type of invention. But examples I could give of things that would be patentable in a software context would be things that, again, that improve the computer itself. So if you've come up with a new data encryption algorithm, or a new communication protocol, things that help the computer perform more efficiently, or do things that it previously could not do. Things like that, those technical improvements to a computer are patentable subject matter. Again, as long as we go into those technical details in the application, as far as how that functionality is actually implemented, how the computer is actually doing these things. The other end of the spectrum would be things like where the computer is simply just being used as a tool to carry out some general process, rather than that process improving the computer itself. So if you came up with software that could calculate interest rates or something like that, even if you came up with a new mathematical formula to do that, that formula could technically be performed without a computer. Granted, not as efficiently, but it could be done without the computer. And so in cases like that, the computer is viewed as more of just a tool to carry out the process, rather than the computer really being improved upon. And sometimes it's just a matter of semantics. And that's something that you don't necessarily need to worry about yourself, because again, once you get to the non-provisional step, that's where a patent attorney or patent agent would come in and help you beef up the language and put everything in proper patent format, which I'll get to in a little bit. But the key, though, is, again, if you're going to be trying to provide or prepare and file a provisional application yourself, the more those technical details you can throw into that first disclosure, the better off your subsequent non-provisional application is going to be. So just be as technical as possible. Talk about how the computer is being improved, kind of what the problem was before your invention came along, and then again, how those technical, how that functionality is actually implemented from kind of step 1 to step 100, if there's that many steps, but just being as technical as possible as far as the algorithm that the computer goes through. And you don't have to provide source code. Just like a pseudocode level type of description would suffice. But again, all that's to say is just be as technical as possible if you're talking about software. And I'll get into kind of the other things that you'd want to throw into a provisional later on, but just wanted to mention that here. And yes, so just real quick, everyone, I will provide a copy of the slides to Philip, and he can distribute them. And there'll be a couple other documents that I'll give to Philip as well to give to all of you. So don't worry about trying to take notes or anything. You'll all have a copy of the slide deck. So beyond that threshold issue of patentable subject matter or not, it ultimately boils down to the invention needing to be sufficiently unique compared to everything that's come before it. And what I mean by that is basically anything that's in the public disclosed, it's been publicly disclosed, anything that's publicly accessible is what falls within the universe of what we call prior art. And so it doesn't have to be a patent application or a published patent. It could be any what we call non-patent literature, just anything. It could be a YouTube video, it could be a product catalog, it could just be a product that's on the market. It could be an academic paper, anything that's publicly accessible. It falls within this universe of prior art that can be taken into consideration by the patent examiner in determining whether what you've come up with is sufficiently unique. And technically, there are these three standards. The first we call usefulness, which is kind of a throwaway standard because you can argue that any invention is useful. Novelty just means that what you come up with is unique. No one's done this exact same thing before. So as long as what you've come up with has at least one unique aspect to it, you're going to satisfy that novelty standard. The third and the most difficult standard is what we call non-obviousness. And basically what that means is, again, taking all this universe of prior art that's known to, theoretically known to a person having ordinary skill in the art. And that's what that FOSITA acronym stands for. Basically, a person having average skill in this particular technology, field of technology, having all this universe of information accessible to them. Your invention can't simply be an obvious combination of or an obvious improvement over those things that had come before it. So again, this is all kind of case by case and it's very subjective, but that's something that we always look at when we're going to file a patent application, is whether what you've come up with is really unique, or if it's just kind of the next logical step in the evolution of this particular technology, or are you just kind of combining known things into a single invention or a single product, or is there really something extra there that's never been done before? And so that's kind of what we look at as far as whether, after you clear that patentable subject matter threshold, whether what you've come up with is sufficiently unique compared to all this prior art teaching that might be out there. So another thing to keep in mind is it's not required that you have a working prototype before you actually go down this path of filing a patent application. I mean, obviously, the further along in development you are, typically the stronger the application is going to be, just because as you develop something, there might be additional problems you encounter, and then you have to find solutions to those problems in order to make your thing work. And in those solutions, there might be additional subject matter that could be patentable as well. So the further along you are on the process, the better sometimes your chances become of getting a patent. But that's not to say that you couldn't file something sooner. And you can always file multiple patent applications if, depending on how development goes and how long development takes. But technically speaking, as long as you've got it figured out in your head and you can describe it in words how your invention will work once it's developed, that's enough to get a patent awarded even. Certainly it's enough to file a patent application. So you don't actually have to have a working prototype before you move forward with any of this. Another big thing to keep in mind is this issue of public disclosure. I kind of mentioned this earlier, but in a nutshell, public disclosure is really any disclosure that's not covered by a confidentiality agreement or a non-disclosure agreement. It could be any kind of public use, public display. It could even be a sale or an offer for sale, or any kind of public commercial exploitation of the invention. Anywhere in the world. And I mentioned the commercial exploitation because, again, using software as an example, where what you're patenting is the algorithms, and those algorithms aren't necessarily going to be publicly disclosed or publicly accessible even by the end user. But the fact that you're commercializing those algorithms counts as a public disclosure under the patent rules. So what that means is, or I should say where that comes into play, is you basically, you want to get your patent application filed before any of this public disclosure takes place. Now, in the United States, there is this 1-year grace period, meaning if you do publicly disclose before you file your patent application, you do have a year from that date of first public disclosure to still file your application, and you're going to be okay. Now, if you wait beyond that 1 year, your own public disclosure becomes part of this universe of prior art. And so your own public disclosure would basically prevent you from getting a patent if you wait longer than a year to file that application. However, that's just in the US. And so if you have any desire or potential desire to pursue patents in other countries, or if you're trying to set your company up for acquisition and you want to keep those options open to whoever might acquire you, you want to file your patent application before any of that public disclosure takes place, because there really is no grace period outside of the US, meaning that if you want to get a patent in China or Japan or Europe or elsewhere, you've got to at least get your US application filed before any public disclosure takes place. If you even publicly disclose a day before you file your first patent application, that's enough to prevent you from getting patents in these other countries. And so again, maybe it's not something that's in your budget or of interest to you to get patents in other countries, but if you are potentially looking for an exit where you might sell your company or sell the technology or even license the technology to other companies, better to have or to keep those options open, just to make your intellectual property that much more valuable to someone who might acquire you or who might license this technology, because maybe they have the money to then pursue these patents in other countries. So again, all you have to do is just file in the US before any public disclosure takes place, and you're going to keep all these options open. And if you do have to disclose to people in the meantime, like let's say you need to hire a programmer to help you actually code your idea for your software program, or if you need to hire a manufacturer to make your widget, just have them sign non-disclosure agreements before you tell them anything. And then those disclosures would not be considered public disclosures, because they'd be confidential disclosures, and then you don't have to worry about these issues in those scenarios. So yeah, just keep your inventions confidential until you're patent pending, which means once you have an application on file with the patent office, you'd be patent pending at that point, and then you're okay to publicly disclose after that point, because you've locked in your filing date. That filing date predates any public disclosure. And then as long as you string your applications along, which I'll get to here in a minute, you're going to be okay. So there's different types of U.S. patents. Specifically, there's 3 different types. We'll really focus on utility during this presentation, just because that's the only type of application that can have a provisional. There are design patents also to protect the way something looks rather than the way it functions. Again, I'm happy to answer questions about that if anyone has any. And then there's a third type that's called a plant patent. If you develop some new asexually reproducing plant, you could get a plant patent on that. That's not something I handle personally, but I could refer you if that's something that applies to what you're doing. But utility patents, though, that typically is the type of patent that most people know about, and the type that most people are most interested in, just because it tends to be the broadest form of patent protection. It's the longest form of patent protection you can have. And basically what you're doing is you're protecting the structural or the functional features of your invention, or in other words, the way your invention works, as compared to design patents, where you're not protecting how your invention functions, but literally just how your invention looks. So if your invention has a unique look to it, you could get a design patent to protect that look. It's also possible to get both utility and design patent protection on an invention if it qualifies for both. So that's something to keep in mind as well. But also keep in mind that design patents cannot be branched out of a provisional application. So if a design patent is something you want to pursue, that needs to be something that you separately file, again, preferably before any public disclosure takes place. So you would file a provisional application and then a design patent application kind of in parallel if you want to keep both options open. Otherwise, if utility is the only thing you're interested in, or only thing that could really that would be viable for your invention, then you just have to worry about filing the provisional application or non-provisional. But again, we're talking about provisionals today. And there are similar types of patents in other countries, so at least for utility and design patents. All right, so U.S. provisional applications. As many of you, I'm sure, know, it's essentially a provisional is an optional first step that can be taken for utility patent protection. What it does is it basically just holds your place in line for up to 12 months. All the while your invention is patent pending, but it's literally just a formal invention disclosure that you're submitting to the patent office. It's not necessarily even looked at that point in time by the patent office or by a patent examiner. It's literally just rubber stamped, and you're given a filing date. You're kind of putting your stake in the ground, so to speak, as far as your official filing date for this invention. Ultimately, you have to follow up by filing a non-provisional application. And preferably you file that non-provisional within 12 months from filing the provisional application. And so what you do is you file the provisional first. That holds your place in line for up to 12 months. And within that 12-month period, you file the non-provisional. And then the non-provisional is backdated and given the same filing date as the provisional application. So it's as if no time is lost, basically, as far as the filing date's concerned. What we call that is claiming priority. So the non-provisional claims priority to the provisional, meaning that it's going to be given the provisional application's filing date. The key, though, is that you're not automatically given that priority claim, but rather once you file that non-provisional and you attempt to make that priority claim, the patent office at that point is going to then look at that provisional and compare it against what you're trying to claim in the non-provisional. And they make sure that what you're trying to claim in the non-provisional was actually disclosed to a sufficient degree in the provisional. So that provisional has to lay a strong enough foundation for you then to build upon it with the non-provisional. And if that foundation is lacking in detail in that provisional application, you're not going to get the priority claim. And what that means is that rather than this non-provisional being backdated and given the same filing date as the provisional, the non-provisional is going to stand on its own filing date. So you potentially lose 12 months, up to 12 months, where you could have gotten an earlier filing date if you don't provide enough detail in that provisional application. And again, I'll get into some of those details that you should include in a little bit here, but that's key if you're going to try to file your own provisional application, is making sure it's got enough detail in there to support that priority claim. So again, a U.S. non-provisional application, the one that you file after the provisional, that's the type of application that's ultimately going to be examined by a patent examiner. And that's the type of application that could potentially turn into an issued utility patent. So a provisional application could never turn into a utility patent on its own. It just holds your place in line to then follow up and file the real application. And it's that real non-provisional application that could then potentially turn into a utility patent and then give you those enforceable utility patent rights that you could use to stop others from knocking you off. Let me see. So one other thing I'll just briefly mention, and again, this is not something that you have to worry about yourselves, because in theory, the way this would play out is you would file your own provisional application if you're looking to save money. And then when it comes time to do the non-provisional step, that's when you would really want to talk to a patent attorney or a patent agent. And they would be the ones to help you actually prepare that non-provisional, particularly what we call the claims in that non-provisional. That's the most important part of a utility patent application. And then they can also advise you on then pursuing patent protection in other countries as well. And the most common method of pursuing those international, or I should say those foreign patents, is what we call the PCT process, and that stands for Patent Cooperation Treaty. And essentially, most of the industrialized world, as you can see, there's 153 countries that are currently signed on to this treaty. it's essentially this clearinghouse where you file one application, and it holds your place in line, kind of like a U.S. provisional application does in the U.S. But this PCT application will hold your place in line for basically 30 to 31 months from your earliest filing date. And so you're kind of patent pending internationally during that time. And you can then decide what countries you want to pursue patents in, and start budgeting for those costs. And as long as you file those applications within that 30 to 31 month window, each of those, what we call national applications, those foreign filed applications, will all be backdated and given the same filing date as your earliest filing date. And I've got a little timeline illustration on the next slide that will kind of help better illustrate that. But all I want to convey here is that, again, as I mentioned earlier, there's a way to string these applications along. You don't have to file them all at the same time. And so you've got the luxury of being able to kind of defer some of these decisions and defer the costs associated with those decisions for up to 30 to 31 months in some cases. Without sacrificing any potential protection. Again, though, this is something that you would talk to a patent attorney or patent agent about. They could help you figure out what the costs would be and the timing for all these applications and everything else. But I just wanted to include this just so you have it for your information, and just so you can remember that as long as you file that U.S. provisional application as a first step, you're going to be able to keep all these other options open down the road. So here's that timeline, and particularly it would be the top timeline that would probably apply to you if you're looking to do a provisional application first. So again, it's key to remember that public disclosure cannot occur before you file your provisional application if you want to keep all your options open. If you're looking to keep your foreign filing options open, you want to get that U.S. provisional application filed before any public disclosure takes place. Once that's filed, again, you've got then 12 months to further develop your invention, maybe test the market, et cetera, to just budget for these further steps. You've got this 12-month period to do all that without losing any time or losing a filing date. And then by that 12-month point, again, measured from your U.S. provisional filing date, that's when you would file at least the U.S. non-provisional application. But also, if you're interested in filing in other countries as well, you would file your PCT application at this point. And if there's any non-PCT countries that you might be interested in, which most non-PCT countries are of no interest to most companies, at least the companies that I work with. But you would also file those at this point as well. But basically, if you file these applications by that 12-month date or any time within this 12-month period, these applications will be given the same filing date as this U.S. provisional application. Not to muddy the waters, but if you do file a PCT application, because the U.S. is a member country of the PCT process, you could actually file your U.S. application after the PCT as part of these national application filings. So one way to keep your costs down is file the U.S. provisional. Within 12 months, you file your PCT application. And then within that following period of time, basically 30 to 31 months from your provisional filing date, you file in the countries of your choosing. That could include the U.S. if you haven't already filed in the U.S. And like I said, it can include Europe, Japan, China. I mean, again, most of the industrialized world with that 153 member country list. But again, if you stick to this timeline here, these national applications, even if they're filed 30 to 31 months after your provisional application, they're going to be backdated and given the same filing date as your provisional. And where that really becomes important is with respect to this universe of prior art that I mentioned earlier, because again, prior art is anything that predates your application filing date or your earliest application filing date. So when you file your U.S. provisional application, this basically cuts off the universe of prior art that could be used to determine whether your invention is unique or not. So meaning that anything that comes out publicly after your provisional filing date it cannot be used as prior art against your invention. So the earlier you file that application, the sooner you cut off that universe of prior art, basically. And so whether it's competitors that are trying to come out with competing products or services, or just others that are kind of generally coming up with similar solutions to the same problem that you've solved. If any of that activity occurs after your filing date, none of that factors into your universe of prior art. And also those subsequent disclosures or competitors could eventually be looked at as infringers once you ultimately obtain a patent, as long as you filed your application before their public disclosures took place. So with these national applications, again, if you stick to this timeline, even though they're filed 30 to 31 months after your provisional filing date, they will be backdated and given the same filing date as your provisional application. And so you've basically cut off 30 to 31 months of potential prior art by making that priority claim, by chaining these applications together following this timeline here. So again, the key for you is just to remember to file before you publicly disclose, and talk to a patent attorney or patent agent well before your 12-month period of time is up. So I would typically advise starting to talk to attorneys roughly 9 months from when you filed your provisional. So you give them him or her a roughly 3-month runway to prepare the application, figure out where it's going to be filed and all that, allow you to budget for those costs and everything. I mean, obviously you can talk to people, to attorneys and agents sooner, but at the very least, I would say give them 3 months to work with, just not knowing what their caseload might be and giving you some time to figure out who exactly you want to work with for those steps. But yeah, so this is kind of the general timeline that most inventors will follow. I've just included a design patent timeline as well. Again, not something we're really going to focus on in this talk, but just so you can see kind of how that one looks. You don't have a 12-month grace period, you have a 6-month grace period. There's no real kind of PCT process for design patents. There's something comparable, but not nearly as cost effective as the PCT process. So generally what you do is you file your US design patent application, preferably again before any public disclosure takes place. And if you do and you want to pursue foreign applications or foreign design patents, you file those within 6 months on a country-by-country basis, separate national applications within 6 months from your US filing date. And again, that's something really, I mean, design patent is not something you want to try to file yourself anyway. So that's something I would highly advise you work with a patent attorney on, or patent agent. And again, they can keep you apprised of these deadlines and everything. Okay, so as far as preparing your own provisional application, usually the first step is going to be doing some kind of patent searching, just to kind of get a feel for what might already be out there. I do note that there's no requirement that you actively go searching the prior art to see what's already out there. The only requirement that the patent rules have on applicants is that if they are aware of prior art, they are legally obligated to disclose that prior art to the patent office when it comes time to file the non-provisional. So you don't have to disclose this kind of stuff when you file your provisional, but it is something you want to make note of, so you can provide that to your patent attorney or patent agent when you file the non-provisional, because that's part of what they will need to file with the patent office. If you are aware of prior art and you fail to disclose that to the patent office when you file your non-provisional application. That is considered inequitable conduct, and that is grounds to invalidate any patent you might later get. It's basically considered committing fraud on the patent office. So it's a very serious thing that they look at, and it is a common defense that alleged infringers will try to raise in a lawsuit. They will try to dig up prior art that the patent owner may or did know about and failed to disclose to the patent office. So it's yeah, very serious thing, but again, there is no requirement to actively pursue or to search out prior art. It's just if you happen to know of prior art, or if you optionally decide to search for prior art and you come across some stuff, you then have to disclose it. But so I say that because a lot of my clients, at least, choose to just kind of skip the searching step altogether. Particularly if they're already kind of familiar with their industry, or if they are in kind of fundraising mode and they're going to file a patent application regardless of how broad of a patent they might be able to get at the end of the process. So they don't necessarily care what prior art's out there. They know that there's at least one unique aspect to their invention, and they just want to go into the process and let the examiner do the searching and see what the examiner turns up and kind of react rather than proactively search before filing. But if you are really only interested in pursuing a patent, if you think that you'd be able to get a broad patent, or if you just want to make sure that there's nothing already out there that's similar, then you're more than welcome to do your own kind of searching. And I do searches for my clients as well. But if you want to do just a free search yourself, kind of as an initial step, I always recommend just using Google Patents. And I have the URL here. It's just patents.google.com. And it works just like the normal Google search engine, where you would just use plain English terms that would be used to describe your invention or aspects of your invention. And then Google will provide you a list of results of published patent applications and published patents that use those same terms. So if you're able to come up with nice descriptions, not overly broad, then you might be able to do a pretty decent search just through Google Patents. And that search engine, it becomes more and more robust. It just started out only being the US patent database, but now it includes Europe. It includes the whole PCT database. It includes databases like Japan and China, where there's English abstracts. Canada, I think, is in there. So it's pretty close to like a worldwide database as you're going to be able to get, and at no cost to you as well. So it tends to be a pretty comprehensive search as far as whether if you're trying to figure out whether or not someone's come up with something similar to your invention. And again, particularly that PCT database, where if anyone's going to file in multiple countries, 9 times out of 10, they're going to go through the PCT process to do that. And so that PCT database is pretty robust. You could probably search just that on your own by itself and come up with some pretty comprehensive results. But again, Google just combines all these databases in a single search. And again, free of charge, really user-friendly, more user-friendly than the US PTO databases. And so that I would advise doing that as a first step if you are someone who's interested in doing an initial search to see what might already be out there. So the provisional applications, as far as what you would put into them, the biggest thing to keep in mind is that there is no required format. So a lot of people I talk to, they bog themselves down in looking at other patents, and then they try to mimic that language that's used in these patents, and they just get so caught up in the language that they kind of get lost and don't necessarily describe things as best as they could as far as their invention. So I mean, you can look at other patents just to kind of see what those look like, but just keep in mind that those are non-provisional applications. More often than not, they've been prepared by an experienced patent attorney, and sometimes patent attorneys that aren't very good. And so sometimes you might get bogged down in low quality patents and not even realize it. So for all those reasons, just it's not something you need to worry about, because with provisionals, there is no format. As long as the information is in there, it could be a combination of a written description and drawings to illustrate things, or it could just be a written description. However, it's best conveyed to describe your invention, how to make and use that invention. The information just has to be in there in some form or fashion. Now, when it comes to filing the non-provisional application, that's where everything will be put into the proper format. The attorney or the agent will add the claims and all that kind of stuff. And so that's why you pay the attorneys and the agents, because they're going to take everything and put it in the proper format. For your purpose, for filing your own provisional application, however it's easiest for you to put that information into an application or into a disclosure, that it'll work as long as it's got enough detail in there. And we'll talk about what details in a minute here. But yes, don't worry about writing claims. The provisional is not going to be examined. You don't have to have claims. You don't have to use legal jargon. Just describe things in plain English, and in a way that could be understood by someone with knowledge in that field. So you don't have to overly explain things that are already well known. So again, for example, if you're talking about software and it's going to be executed by a processor, you don't have to explain what a processor is or how a processor works, things like that. Now, if your invention is a better processor, in that case, you would obviously want to describe how that processor is better and why. But just put yourself in the shoes of someone with kind of ordinary or average skill in that particular technology field, and it's going to be presumed that whatever the average person would know, that the reader is going to know that information already. So you don't have to go into that level of detail. You just want to focus on describing what you believe are the unique aspects in your invention, because that's what you're teaching. That's what's new, and that's what no one else knows about, presumably. And so those are the aspects that you want to teach the reader in your description. So again, if it can be done just solely in writing, great. If you need some drawings or photos, like if we're talking about a widget of some kind of mechanical device, drawings or photos would help convey what it is you're describing in words. If we're talking about processes, whether software or methods of manufacture, things like that, flow diagrams might help convey the different steps in the process. So again, whatever you think is going to help convey your invention to the reader, any and all of that would be good to include, but none of it's required. It's just the rule of thumb is whatever it takes to help teach someone how to make and use your invention. And I say that, but remember that no one can make and use your invention without your permission, as long as your patent is actually active and enforced. So that the theory is that once that patent eventually naturally expires in roughly 20 years, then the public would be able to take your patent, use it as an instruction manual to make and use that invention, and in theory, improve upon it with the next best version at that point. So that's the whole trade-off with the patent system, is that by granting this limited monopoly to the inventors, that the patent system is encouraging disclosure and encouraging the sharing of information, so that you're kind of bringing up technology, and helping to further that technology. Either yourself or one of your peers could come up with the next best version of that technology by virtue of that disclosure. But again, while a patent is supposed to be a blueprint to make and use the invention, no one can do that without your permission, so long as that patent is in force. And as I mentioned earlier, the failure to provide adequate details is going to result in that subsequent non-provisional application not being able to get that priority claim. So it's important to be as detailed as possible in your disclosure. Again, not in a particular format or anything or a specific format, but just get the information in there in some form or fashion. So as far as what details to include in a provisional application, it's always good, and this is both for provisionals and non-provisional applications, it's always good to start with what we call a background history. And essentially, you're kind of setting up your invention as being the solution to these problems that had existed before your invention came along. So the background history essentially talks about kind of the current state of the art, if you will, and the problems that you've seen with that current state of the art. And then that kind of is then used to segue into a discussion about your invention, how you basically say that essentially my invention solves all of these problems that were existing in the prior art. And then after that segue, you then talk about, okay, what your invention is, how it solves those problems, etc. So as you see in this list here, how the invention works to accomplish its objectives. So you're saying that your invention solves all these problems that existed in the prior art. Well, how does it solve those problems? What does your invention actually do, and in order to solve those problems? If we're talking about some kind of hard good or mechanical device, it's always good to have just discuss each of the components. And as a starting point, before you actually start writing your disclosure, you might just have a list, just list out all the different components that you have in your invention. And then for each of those components, just kind of write like a little short description about what that particular component does. You can also talk about where it's positioned relative to the other components, how those components might interact with one another, how they might be engaged with one another, whether permanently engaged, removably engaged, maybe it could be either of those things. So just kind of come up with a parts list basically, and just do a little write-up for each, what it does, where it's positioned, how it's engaged, how it interacts with other components, those types of things. It's also good to talk about all possible things like materials of construction, sizes, shapes, dimensions, etc. for each component. And it could be the case that you might have come up with already a preferred embodiment, as far as maybe this thing is best made out of some kind of metal or plastic. But maybe in other embodiments, it could be other materials, now known or later developed. That's kind of a catchphrase that we oftentimes used, now known or later developed, just to kind of have a catch-all, just in case someone comes up with some brand new material 10 years down the road that could be used to make your invention. You want to be able to say that was within the scope of your patent claims. And so while you might have preferred materials, think about all the possible materials that could be used. Same thing with sizes and shapes and dimensions. Maybe there's a preferred size, shape, and dimension for your device, particularly if we're talking about mechanical devices. But if there's other sizes, shapes, or dimensions that could work, maybe in other use cases, for example, it's always worth mentioning those other possible versions or embodiments as well. Again, the key is that we're being as detailed and as robust and as broad as possible, because whatever we include in this provisional application, we're going to build on that when we file the non-provisional. We're trying to provide a solid foundation on which to then file that non-provisional application. So again, in addition to that type of those types of alternate embodiments, I mean, there could be other additional components or different ways of doing things that could be utilized in alternate embodiments as well. And so just think about all possible ways that your invention could be made, and also all possible ways it could be used. And the helpful thing to do is to try to place yourself in the shoes of a competitor. If you were looking at this patent that was filed by a competitor, how would you try to work around that patent? And then if you're able to come up with workarounds, make sure to include those in your application, in your disclosure as well, as alternate embodiments, basically. So we want to try to provide as much potential coverage around your invention as possible, and any holes that you might be able to find, the competitors might try to take advantage of. We want to try to plug those holes by discussing all these potential embodiments, so that those embodiments would fall within the scope of your ultimate patent rights, hopefully once you follow up and file the non-provisional and obtain that utility patent. Another thing to include in a provisional are any additional features or embodiments or components that you might someday incorporate into future versions. So maybe you already have kind of, even if they're pie in the sky ideas for versions 3 or 4 or beyond, for your invention, better to just disclose those details now, at least as far as the level of detail you've got fleshed out, just to have it in there. Just to potentially allow you to claim some of those features down the road, or at the very least, just to put it into an application that will ultimately be published eventually, so as to create prior art to prevent anyone else from coming along and trying to get patents on those features. So even if you may never include some of those embodiments or some of those components or features, if you might at some point, or if you fear your competitors might try to do something like that, just include mention of those alternate embodiments as well. One thing to not include would be anything that you might try to keep as trade secret information. Obviously, we didn't really talk about what a trade secret is, but essentially it just boils down to confidential information that you don't want it to disclose to anybody, that you want to keep protected as what we would call a trade secret. Like, think the Coca-Cola recipe, for example. So if there's any aspects of your invention that you don't want to disclose, whether if it's software, maybe there's certain algorithms that you just want to keep server side, keep confidential and never disclose. If it's some kind of widget or mechanical device, maybe the actual method of manufacture is something you don't want to disclose to people. So if there's any aspects that you want to keep confidential, do not put them in your provisional application. Now, a provisional application isn't necessarily going to be published on its own. However, so for example, if you were to file a provisional and you don't follow up and file a non-provisional, that provisional will never see the light of day. But if you do follow up and file a non-provisional application, when the non-provisional is published, the provisional will also be published at that point. And so because of that, anything, again, if there's anything you want to keep confidential, don't put it in the provisional, because it could potentially see the light of day eventually when that non-provisional is published. The other thing that I didn't mention earlier is that when you file the provisional and you later file the non-provisional, during that 12-month period, it is possible that you could develop further improvements or flesh things out further after you've already filed the provisional. And as long as you've got adequate support for those general details in that provisional, then when you file the non-provisional, you can include all those additional details you've developed in that 12-month period, and still potentially get that priority claim. Now, you're going to get the priority claim either way for anything that was already disclosed in the provisional. So if the provisional disclosed A, B, and C, and the non-provisional has A, B, and C, then those A, B, and C features will be backdated and given that earlier provisional filing date. If during that period of time after filing the provisional, you come up with new feature D, you can still include D in the non-provisional, but D is going to stand on the filing date of the non-provisional rather than the provisional. And I don't want to muddy the waters too much with that, but all that's to say is that one of the benefits of a provisional application is that you can file it now with all the details you have figured out. you're patent pending on those details, and you can use the next 12 months to kind of fine tune things, further develop the invention, etc. And then when it comes time to do the non-provisional, you can include those new details at that point as part of kind of building on that provisional disclosure. Um, but yeah, as far as what to include in the provisional, again, this is, I think, a pretty solid list as far as just guidelines to follow. Again, keeping in mind that there's no specific format required. Just get the information in there in plain English, be as detailed as possible, as robust as possible in that description. And you're going to set yourself up nicely then to then later file that non-provisional. And again, don't worry about claims, don't worry about specific format. You might think that, well, if I do it in the right format now, it's going to save me money when the patent attorney takes over, because they're not going to have to do as much work. But in my experience, even when clients try to prepare their own claim set or try to follow like other patents as far as how they're structured, how they're written, usually in those cases, I end up spending more time trying to rework things than had the client just given me just plain English descriptions to start from, because a patent attorney is usually going to have their own preferences, or particular strategies might require things to be reworked, reworded. And so it tends to not be time well spent trying to put a provisional application into any specific format. So just convey things clearly, plain English, be as detailed as possible, and that's going to be your best bet as far as in following up with that non-provisional step. So if you are going to file it yourself, the easiest way to file these days is electronically through the Patent Office website. It is still possible, I believe, to file in paper, but things could get lost in the mail. It costs a little more money, obviously, to file in paper, both in filing fees as well as postage. But with the electronic filing, it's cheaper. They charge lower fees. You're legally patent pending as soon as you hit the submit button after you upload the documents. They give you an acknowledgement receipt right there. They give you your application number and everything as soon as you click the submit button. So it's just a more secure way to submit these applications, and a cheaper way. They have what's called the unregistered filing option, so you don't actually have to have an account with the USPTO. The accounts are free to set up anyways, but if you just wanted to submit without creating an account with them, here's the URL to do it. And what it does is it takes you to an upload screen, and it just lets you upload the documents you need to upload. And so I've listed them here. And this is kind of the bare minimum of what you need to include to file a provisional application. So the first thing is what we call a specification, or basically this is just that written description that you've created. So probably you would start with it as a Word document. And then before uploading, you can either upload it as a Word document. That's a recent change that they made with this system, a docx file, or alternatively, and what I recommend doing if you have the software to do it, is convert that Word doc to a PDF and then file that PDF as your specification. If you have any drawings to accompany that written description, that would be a separate PDF file. And you could have figure numbers or element numbers pointed to them, or not. Again, it's just there's no specific form or fashion that these have to be filed in. All that stuff can be cleaned up at the non-provisional step. But if you do have any accompanying drawings that you refer to in your written description, you would just separately include those, just like as a single PDF. If you have 10 drawings, there could be 10 sheets of drawings in that PDF, 10 pages of drawings, however many there needs to be. You would file that as well, or upload that. And then there's what's called a provisional cover sheet, which that's one of the forms I'll give to Philip to distribute. You'll see it just has basic info, just legal name, address, things like that. Nothing real difficult to provide. For most of you, there would also be what's called a micro-entity certification form. And so By default, when you file an application, you're considered a large entity, but if you file the right paperwork, you could get discounts on the official fees, the filing fees and everything, if you qualify as either what's called a small entity or a micro entity. So if you are a solo inventor or just individual co-inventors with no company formed or anything, or if you do have a company formed and your company has less than 500 employees, you would at least be considered a small entity. And that gets you a 50% discount on official filing fees. Now, if you also satisfy these three standards here, then you would qualify as a micro entity, which gives you a 75% discount on filing fees rather than the 50% discount you would get as a small entity. So if you are a first-time filer or a new company, and the big one to look at is whether your gross pre-tax income last year was under this number, which this number is always changing, but this is where it currently stands at. Then you would likely qualify as a micro entity. And if you do, then it's just this little one-page form where it's got a couple check boxes. You don't even have to specify your income or anything. You just basically check a box that says your gross income was under this number. If you submit that as part of this provisional filing, then you would qualify as a micro entity as well. And so as you'll see here, the filing fees, which you pay at the time of filing your application. Currently, it's $70 if you're a micro entity. If you're a small entity, it's $140. And that's all you have to upload as part of a provisional application filing. And then, like I said, they'll give you an acknowledgement receipt immediately with your application number. You want to take note of your filing date and then calendar 1 year out exactly from that date, because that's going to be the hard deadline by which you're going to want to file your non-provisional application. And like I said, 9 months out from that provisional filing date, you should put a reminder in your calendar to start talking to patent attorneys or patent agents to help you with those next steps. Now, the other thing that you might have as part of your filing, if there is a company involved, then you would want to have what's called an assignment document, whereby you as the inventor, or if there's more than one, you co-inventors each sign your ownership interest over to the company. So it's the company that owns the IP rather than any one individual. Now, that goes to, again, patent ownership, and just a couple notes on that. So the default rule, if there's no written agreement, the default rule is that each patent co-inventor has an equal undivided ownership interest, and there's no profit sharing obligations to any co-inventors. So what that means is that, let's say you and a friend develop some new technology, you file a patent application on it, etc. Maybe you ultimately get a patent. If there's no written agreement between the two of you, then you each have an equal undivided ownership interest in that technology, which means, hypothetically, if you have a falling out and you each go your separate ways, you legally could both start competing companies and commercialize that technology and compete against each other and not have to share profits with either. And so it could just create issues like that. And as an attorney, I always have to think worst case scenario. And unfortunately, I have seen the worst case scenario play out with this type of falling out scenario. And so my advice is always, particularly if it's more than you involved in the development or within this company, or I should say within an endeavor developing something, if it's you and multiple other people or one or more other persons, always best to form a company sooner rather than later, whether it's an LLC or a corporation, et cetera, and then have everybody assign their ownership interest over to the company. That way, if there is any falling out down the road, the company is going to maintain ownership of that IP, and you're not going to have to worry about some former partner or person within that company going off and spinning off their own competing company using that technology. Now, obviously, if you do go that route and you form a company, there's going to be terms within that operating agreement that would dictate what happens if a partner should leave. There probably would be bought out, things like that. But the key is that the IP would remain within the company and it couldn't be pulled out and spun off into a competing company. There's other reasons to form a company as well, as far as just offsetting liability, insulating your own personal assets from any kind of judgments that could be rendered, whether it's breach of contract or products liability claims, etc. There could also be tax reasons why you'd want to have a company and just keep your personal and business assets separate. But if, like I said, if there is more than one person in this endeavor with you, better to start thinking about forming a company and transferring that ownership interest sooner rather than later. Another thing to keep in mind as far as patent ownership issues, just because you pay to have something created does not automatically mean you own that creation. What I mean by that is when you hire somebody, whether it's an employee or an independent contractor, you want to have a written agreement with that individual. And you want that written agreement to mention the fact that anything that person creates within the course of their or the scope of their employment is the property of the company or you, the employer. And so it's usually just some kind of assignment clause built into whatever overarching agreement you have with that individual that would cover things like payment terms, expectations as far as deliverables, things like that. It would also talk about typically confidentiality, but again, there should also be an ownership section that essentially says that I, the employee or the independent contractor, agree to assign all right, title, and interest over to you, the employer. Because if you don't have that language, you run the risk of a court ruling that that person as the creator or as the inventor still retains an ownership interest. And you would think that, well, you paid this person, you should own whatever they create, but that's just not always the case. And it really varies state to state and sometimes even court to court. But some courts would just rule that you would have what's called shop rights, or basically you as the company or the employer would have a license to commercialize that technology, but you don't own it, meaning that that employee or that independent contractor could also commercialize the technology or license or sell it to somebody else as well. And so, yeah, just make sure you get these things in writing if you are working with any other individuals that you've hired, either as an employee or an independent contractor. Get this stuff in writing before you actually have them start working on whatever you hire them to do. So again, bottom line is ownership typically requires some kind of express written agreement, not just an oral agreement or anything. Just get it in writing. That way, there's no argument down the road as far as who owns what or what the rights and obligations are of each party. Yeah, get it in writing, and you don't have to worry about those issues. So that's all I have on patents and provisional applications. The rest of the slides we're going to be on trademarks, but we're definitely out of time here. So again, I can talk to Philip if there's interest in having me come back and talk about trademarks, how to clear your own trademark, even file your own trademark application, things like that, again, to keep your costs down. I'm happy to come back and give that presentation, but otherwise, again, I'll give the slide deck and those forms I mentioned to Philip, and he can distribute it to everybody. I'm just looking at the chat here. So the written agreement, it doesn't necessarily have a particular title. I mean, if it's just an agreement that covers ownership, typically it's called an assignment, as I say here, but also this assignment language could be built into any other type of agreement, whether maybe you've got an independent contractor agreement, again, that covers the whole scope of the relationship as far as compensation, delivery dates, deliverables, things like that. You could have the confidentiality type language within that agreement. You could also have the assignment language within that agreement. So it doesn't have to be its own separate standalone agreement. It could be built into larger agreements. But the key is that, yeah, the key word is assignment. So if you were to do a Google search for like invention assignment or independent contractor assignment, something like that, you might be able to find some language you could use. Otherwise, that's something that I do for a lot of my clients, is I prepare these types of agreements for them, or I review anything that they might find. And so I can definitely be flexible with that as well. If they're looking to save money and just want to maybe like a quick spit and polish on an agreement they prepared or that they downloaded off the internet, I can do that rather than prepare something from scratch. But yeah, it's always key to get this kind of stuff in writing. Let's see. Someone else asked, tell me a little bit about utility model patents. Yeah, I could answer that question more offline. So some countries like China in particular, they have different types of utility patents where they've got like invention patents and utility model, where utility model is kind of a little weaker than a full-fledged, what we would call a utility patent. Other countries call invention patents. But that's something you don't really focus on in the U.S. You just file a full-fledged utility patent application in the U.S. and then when it comes time to file in specific countries of your choosing, at that point we would determine what's best to file, either utility model or invention. And a lot of times it's going to come down to how close the prior art comes to what you're trying to protect, because utility models, the threshold of patentability is lower. But also the protection is relatively weaker. But because that threshold's lower, if the prior art comes closer, then it might be better to go that route instead of like a full-fledged invention patent. But again, that's all case by case, country by country. But since you'd be focusing on filing in the U.S. first, it doesn't really factor into those initial decisions. So any other questions from anybody at this point? Otherwise, my contact info will be in the slide deck as well. So you're always welcome to either call me or email me anytime you might have any questions about any of this.
Yeah, absolutely. Thank you so much, Justin. I definitely really learned a lot here, as always. I think every time I hear your presentation, I'm taking something new away.
I'm glad.
So that's great.
Yeah, I'm happy to help, and like I said, I'm always happy to answer questions anytime. So just let me know.
Okay. So yeah, absolutely. We'll be. I'll get that slide deck from you. Obviously, for all the participants, I'm pretty sure I'll have all your email addresses through the Eventbrite. I believe that was the only way to access this presentation if you registered on Eventbrite. So I'll go ahead and use that email. If you want a different one, or if I'm mistaken and somehow you got into this Zoom meeting and I don't have your email address, please private message me. I will go ahead and put my email in the chat window as well. And with that, very happy and, very excited to see all of you here, and hope this was really a value for all of you in your endeavors.
Great. Yeah. Again, thank you for having me, and yeah, thanks everyone for sticking around. Yeah, like I said, I'm happy to help. So just let me know.
Okay. Thank you so much, Justin.